Hello everyone. Welcome to the online training program on IPR, database analytics tools and advanced technologies. Today we are going to learn about Introduction to Intellectual Property Rights. My name is Rohit and I'll be taking three modules. The first module is related to Introduction to Intellectual Property Rights, and the second module will be talking about patent searching, and the third module will be taking the real-time inventions and with the help of paid and free database. Especially we'll be using Relecura to do patent searching. So let's see what we are going to learn in this course. In this course, we will be learning about Introduction to Intellectual Property Rights. We will be talking about evolution of IPR. We will be also talking about different IP regimes and emerging IP regimes. Beside that, at the last, we will be talking about Introduction to the Treaties. So let's start with the course. First of all, we should know what are intellectual property rights. As you can see here, intellectual property rights refers to legal rights which are created by human mind, such as inventions, literary and artistic work. They also contain designs, symbols, names and images. The most important part of intellectual property rights is that they are valuable for anyone. So nowadays you can see that all the companies which are big, small, SMEs or startups or even an individual inventor, they are filing patents and gaining lots of importance and commercial benefits with the help of patents and other intellectual property rights. How these intellectual property rights helps to encourage innovation. So the main thing is that the intellectual property rights are the legal rights that cover the privileges given to the individuals. There are certain rights which exclude others to misuse your invention or to work without your permission. So that's why if they are protected, the other person will think about innovating a better version of it. The real thing about intellectual property rights is that we are trying to solve all the problems and coming up with new solutions. Those are new inventions and innovations. As the global technology is increasing, the increase of intellectual property rights and the importance of intellectual property rights are also increasing. Let's see different types of intellectual property rights. Before that, we should learn about evolution of IPR rights. So, what do you think? IPR rights are very new? No. IPR rights are very old and they go back to 500 BC. You can see one example here in 500 BC when chefs in Sybaris, a Greek colony in Italy, were afforded a monopoly for a year on the creation of specific recipes. So it will all started from there, and there are some important instances which are related to statute of monopolies, or you can say Venetian Republic statute, and even Republic of Florence on June 19, 1421. Then it reaches to the era where the first patent was filed and granted on July 31st, 1790. From there, most of the evolution of IPR goes on and new inventions and new laws and new treaties, they all come up and they have made IPR rights more stronger. So let's see what IPR rights are there. There are different IP regimes. They are namely patents, geographical indications, trademark, copyrights, and trade secrets. One by one, we will be talking about them and we will be describing about and what is the difference between them. Let's start patents. Now, what is a patent? A patent is a form of intellectual property that gives its owner the legal rights to exclude others from making, using, or selling an invention for a limited period. Now, suppose if you have an invention and you want to protect it, first of all, what you will do, you will file an application in an office, patent office, and you will, with the help of certain rules and regulation laws related to different patent office, you will get a patent. That patent will be a legal right which will exclude others making your invention, using them, or selling that invention. So that gives you a right so that you can commercialize your product with the help of protected patent. Now in this patent there are different types of patents are there. First one you can see here, utility model. Utility model is similar to the patent, but their life of utility model is less than the patent. It generally varies from 10 to 15 years. And to get a utility model, the criteria of getting a utility model is also less, what you can say is not that restricted as we have in patent. Another aspect of patent is the design patent, which are the ornamental, based on ornamental and aesthetic aspects of the uh, product. Let it be 2D design or let it be 3D design. Those kind of inventions are categorized into design patents. We have also plant patents, which talks about a unique variety of plants. Now, if we talk about another regime, which is a copyright, copyright is also a legal right which is given to a creator who has created it. These rights are related to literary and artistic work. As you can see here, anything creative work which is in the form of books, music, painting, films, even computer programs, database, advertisements, these are all artistic work which are coming under copyrights. Now, if we see the scenario of different types of copyrights works, you can see here literary works which involves novels, short stories, poems, dramatic work, and any other writing aspects. Under musical works, songs, musics. Now, songs and music could be in the language form or in the symbols form. Those kind of work are also protected under copyright. And under artistic work, drawings, paintings, and under motion pictures, movies are protected. Most all the computer programs are also coming under copyrights. If we see the duration of the copyrights, it starts with the creation of the works and it continues until some time after the death of the author. The most common thing under copyrights is we hear that is piracy. Now, in order to understand the piracy, it's very important to understand copyrights. So whenever somebody will unauthorizedly copy some of the like songs or movies or let's say novels, if somebody will copy it and print it without the permission of the author, then it will be considered under piracy. Another IP regime is the trademark, which is a very important regime, and it's very ancient IP regime. Even in the older years, as you can see here, 3000 years ago, Indian craftsmen used to engrave their signatures on their artistic creations before sending it to a different country. Similarly, manufacturers from China also sold goods bearing their marks. It was over around 2000 years ago. Trademark is associated with a company, and whenever you see a trademark, very peculiar thing is that they are not associated with the product. Let's say if we are talking about a trademark of Nike or Reebok, their trademark is not related to shoes, but they represent shoes. So similarly, if you can see here, these are the two trademarks which are related to tea and the petroleum products. They are not related to any, you can't see that they are related to tea or petroleum products, but these are the oldest trademarks till now. Now, trademark can be of different types. They can be of service marks, collective marks, or certification marks. Service marks. Service marks are the marks which deals with services like rental car or you can say airlines. So these are the services that they have created, and if they want to protect it in the trademark, they will register it under service mark. Collective mark is a trademark which is given to a association. It is not given to a individual. That association can use that trademark and they can sell that product. But certification mark is given to a individual and it is been different from the collective mark. There are different ways in which trademark can be defined. Those can be words, those can be letters, those can be colored mark, it could be 3D design, it could also be a sound, or it can also be a smell. There is an important treaty which is associated with trademark, which is a nice agreement. Another IP regime is a trade secret. Any confidential business information which provides an enterprise a competitive edge may be considered as trade secret. So nowadays lots of competition is there, and if you have a trade secret, then it is an upper edge for you. As you can see, few examples are there in our real life like Coca-Cola and KFC. So these both are having their trade secret and they don't have their patent. Most of the important thing about trade secret is that if the trade secret is related to something manufacturing, then it is a better trade secret, because if there is a trade secret related to a product, anybody can do the reverse engineering and they can get the trade secret. But if it is in a manufacturing industry, nobody knows that what is the formula used for manufacturing that product. So if a trade secret is there which is related to manufacturing, it's better. And another important thing is that there is no age of that trade secret. But the disadvantage of a trade secret is that if it is out, if it is being conveyed to the competitors, the whole product will be lost and it will be a big loss. So we have to play a certain rules and regulations to protect our trade secret. There could be a different kinds of threats to a trade secret. External threats like network attacks or accessing source code. Internal threat like information could be passed to competitor by an employee. Another IP regime is geographical indication, which is related to a sign used on products that have a specified geographical origin and possess qualities or a reputation that are due to that origin. Now, geographical indication is a IP regime which is related to a place or product which is grown in a specific condition of soil or climatic conditions. Let's say if we are talking about Darjeeling tea. So Darjeeling tea has a specific conditions in Darjeeling, a climatic condition and a soil condition. There only that Darjeeling tea can be grown. If you want to grow the same kind of tea somewhere else, it will not get the same climatic conditions and soil conditions. The quality of that tea will not be same as Darjeeling tea. So anything which is related to a origin or that part of the country, a geographical indication will be given to that place and it is a group intellectual property rights. It's not given to a individual. People who are all selling Darjeeling tea, they can use their GI mark and they can sell their products. Geographical indications are typically used for agriculture products, foodstuffs, wines and spirit drinks, handicrafts and industrial products. Apart from these IP regimes, there are certain emerging IP regimes also which are going very popular nowadays. One of them is industrial design. A registered industrial design or a design patent is the right to prevent third parties from making, selling or importing articles bearing or embodying a design which is a copy. So industrial design is related to the design of the product. So you must be knowing that very important case history of industrial design is Apple versus Samsung. So even the if we have the phone design which is very similar, they can be infringing. And industrial design are related to design patents, and in some countries they are also known as registered design, and they protect only the appearance or aesthetic features of the product, whereas the patent protects an invention that offers a new technical solution to a problem. If you want to protect a graphical user interface, that can also be protected. Another IP regime is related to semiconductors and integrated circuits. They are related to the trace marks of semiconductors or integrated circuits, or the topography of integrated circuits. Nowadays, so many semiconductor and integrated circuits are there, and different applications are used, so that the product will be more faster, there will be less thermal issues. In order to save that, in order to protect that, these new IP regimes or emerging IP regimes are there, which are in order to prevent unauthorized copying of layout design, to provide incentive for investing in the field. Now, the term of protection varies from country to country, and as per the TRIPS agreement, members must provide a minimum protection to at least 10 years for filing the application in this area of integrated circuits. And there is a treaty also. A diplomatic conference was held in Washington in 1989, which have considered this treaty, and so that it can be valid all over the world. Now we talks about different treaties which are very necessary. So first of all, we should know that why these treaties are signed and what is the importance of this. So as you know that intellectual property rights are territorial rights, but somebody wants to sell their product in different countries, so their patent should be protected in those countries also. So these treaties help all the individual countries and inventors and the companies, so that their rights are safe in other countries also. So one of them is the Paris Convention. The Paris Convention was adopted in 1883, and it applies to industrial property in widest sense, which includes patents, trademarks, industrial design, utility models, service marks, almost all intellectual property rights. There are three main categories which comes under Paris Convention. The first one is related to national treatment, second is related to right of priority, and the third one is related to common rules. So in national treatment, what is defined is that each contracting state must grant the same protection to nationals of other contracting states that is grants to its own nationals. So let's say if somebody is coming from India and he is filing in European country, so he will get the same kind of protection as their nationals are getting. Another aspect related to Paris Convention is that is of rights of priority. What it means is that This right means that on the basis of regular first application filed in one of the contracting states, the applicant may within a period of 12 months, or in the case of utility model 6 months, or in the case of industrial design 6 months, apply for the protection in any other contracting states. So right of priority, as other people get in their national states, the contracting states will also get the same rights. And the third one is related to the convention lays down a few common rules that all contracting states must follow. So all the rules and regulation which are there, which will be common for all the contracting states. So all the members of Paris Convention, who are the member of who has signed those treaties, they should follow all the rules and regulation which are mentioned in Paris Convention. Similarly, another treaty is related to Budapest Treaty. And the Budapest Treaty is a specific treaty which is related to microorganism. And before, like if somebody wants to file a patent related to microorganism, they have to deposit the microorganism in some of the place which is known as authorized depository. So if somebody wants to file a patent in different countries and they are in India, so or maybe they have to file a patent in different countries, so they need not to deposit their microorganism in all the countries because of this Budapest Treaty. It helps us to save them money, because instead of depositing the microorganism in each and every contracting states in which person files a patent referring to that microorganism, person will deposit the only once with one depository authority. So you have to deposit the microorganism only to one authority, and it will be considered by all other states. So this is the helpful treaty which helps the people or inventor. This one is the very important Hague Agreement. It is related to industrial design, and it was first adopted in 1925. Agreement was done between all the countries or contracting state which are signed this treaty, and it helps us to simplify the management of industrial design registrations. So since it is possible to record subsequent changes and renew the industrial international registration through single procedural step. So you need not to follow all the countries their different steps. If you go to a WIPO and you file the industrial design there, you can cover at least 100 contracting states. TRIPS is a very important agreement that has been signed with all the countries which are part of TRIPS, and it's come under World Trade Organization. The TRIPS full form is trade related aspects of intellectual property rights, and they came effect on 1st of January 1995. The major feature of TRIPS is that three features are there: standard, enforcement, and dispute settlement. So under standard, all the conventions which are under WIPO and all the standards should be followed by all the countries or the members of WTO who has filed, who has signed this TRIPS agreement. Under enforcement, if somebody has to enforce the intellectual property rights or laws related to intellectual property rights, if somebody wants to protect it, the law should be enforced so that all the people should follow that. That enforcement is taken care by TRIPS agreement. And if there is any dispute settlement between two countries related to intellectual property rights, TRIPS take care of that. Recently, you must have heard about this, that India and South Africa has seek waiver on some provisions related to World Agreement that regulate intellectual property rights related to this COVID-19 pandemic. So under this, the waivers of TRIPS obligation, this is an initiative to ensure availability of affordability of medical products so that everybody can get the vaccines and the drugs related to COVID-19's, which are creating hindrance with because of intellectual property rights. So 2nd of October they have filed this application, and 15th of 16th October the decision will come from WTO. So these are the treaties and the introduction to intellectual property rights. In the next class, we will be talking about patent searching, and after this, there will be a short quiz for you. So you can go through that quiz. You can apply that quiz. Please attempt it. And if you have any questions related to this presentation, you can always contact us. These are the some of the references. You can go through that. If there are some questions to be answered, you can also write us to support@relecura.com, and I'll be meeting you in my next section, and we'll be talking about patent searching. So thank you for listening to this video. If you have any questions related to this presentation, please write us to support@relecura.com. Thank you. Thank you very much.